So we got a whistleblower. Apparently, there's a whistleblower that's trying to intervene in the UMG and Drake lawsuit. Now, this isn't technically a bad thing. It's technically not a good thing. It's actually a neutral thing that is occurring right now. So there's this man named Joe Cat, or that goes by the original name Joseph Reyna, who's actually notified the court as an amicus. And if you don't know what an amicus is, they're a friend of a court who actually intervenes in situations like this as a friend of the court. And essentially, an amicus or an amicus curiae is a person or organization that is not a party to the case, but offers information, expertise, or insight that may help the court decide the case. Courts can choose whether or not to consider the amicus brief. So the court could decide if they want this person's help or not. Rather they want the insight that they have that could help the court. It's up to them if they want to let this whistleblower, in quotations, if they want the information that they have to help them out in this case. Now, usually the purpose for an amicus is to provide context, broader implications, or technical legal arguments that the actual parties might not cover. Bringing information that might not be discussed or might not be covered by UMG or Drake, this person apparently has the information that they could bring to the courts that they may or may not discuss or cover in this lawsuit. So this guy, Joe Cat, or Joseph Reyna, apparently has information that he wants to give to the courts. He wants to be a friend of the court. He wants to be able to give them a helping hand and let them know that there's some things that UMG or Drake might not cover in this lawsuit. Whatever it may be, it looks like he's actually tried to jump in and help the court in regards to all of this. Now, the introduction says right here, pursuant to the court's inherent authority and federal rule of appellate procedure 29, I respectfully submit the motion for leave to file an amicus curiae brief in support of neither party in the above captioned matter. Like I said, not trying to help UMG, not trying to help Drake. He's just trying to help the court. He says his name is Joseph Reyna, and I appear pro se as the founder of Dreams Over Dollars, a Texas-based public interest nonprofit. My work is focused on legal documentation of economic suppression, digital gatekeeping, and structural artist disenfranchisement in the music and platform economy. I believe this is some of the things that he talks about in his resume right here. Some of the people that he's worked with in the industry would be Black Smurf, Xavier Wolf, Ja Rule, Ashanti, King Loso, Flip, and Rocky Fresh. He's helped with ticket sales, managing nationwide tours, executing high-pack marketing campaigns. With data-driven marketing strategies, I've built viral reach across the US and Europe, generating significant impressions and engagement in top music hubs. Skilled in leveraging industry connections and audience insights to maximize impact, build loyalty, and expand market presence. So based off of his resume right here, it seems like because he's involved in ticket sales, marketing, and all of these other things, right? I'm assuming that he always watches the numbers. From what it looks like this guy has his hand in the industry for whatever way or however how. That's how he's able to watch the numbers. I'm assuming that's how he's able to watch the data. Interest of Amicus Curiae. As a nonprofit founder, music professional, and documented whistleblower, I have spent the last decade submitting federal filings, FOIA requests, and economic loss documentation relating to systemic harm against independent artists, including whistleblower submissions to the IRS, SEC, FTC, FCC, DOJ, and multiple state attorney generals. And like I said, he's calling himself a whistleblower. A whistleblower is trying to get involved in this case. Apparently, they be watching the data because of their hand in the music industry. And it appears that they're trying to see if they could help the court. Who would have thought out of nowhere a whistleblower would have came to this case to try to help the court out? Now, when he says systemic harm against independent artists, and I take a look at his resume, I think independent artists might be Black Smurf, Xavier Wolf, and Little Flip, possibly. I'm not sure if Ja Rule, Ashanti, or King Los are assigned to anybody. I think King Los might be independent as well. So he might be looking at the numbers because of the people that he's marketed and sold tickets for. So it's possible because he has his hand in the music industry with independent artists, he sees the numbers, and whatever he sees, I guess he wants to give some insight because of that. Because apparently he's already submitted some submissions to other entities before. It says here, my nonprofit mission is to restore transparency and economic equity within creative ecosystems, particularly where algorithmic suppression and platform-linked financial incentives distort visibility and fairness. My direct experience with federal agency silence, documented retaliation, and evidence-based structural analysis gives me a unique position to inform the court about broader systemic concerns, including those not directly addressed by the plaintiff or defendant, that are nonetheless highly relevant to the legal and public interest context of this case. Looks like I have information, not trying to choose sides here, but because of my past experiences, I decided to help the court however way I can in regards to this scenario here. Reason to grant leave to file. The submitted brief does not duplicate any party argument. Rather, it presents evidentiary, historical, and structural documentation critical to understanding the systemic context in which this litigation now resides. This includes whistleblower filing under 26 USC FOIA, which is Freedom of Information Act, responses and denials across multiple federal entities, public record evidence and algorithmic payola, metadata suppression and suppressed royalties, historical continuity between contemporary suppression and legacy artist exploitation. Now, what's interesting about this part is when he says whistleblower filing under 26 USC, because looking that up here, whistleblowing under 26 USC in context, it means reporting someone, a person, or a business who's cheating out an entity, whether it be taxes, for example, for the IRS. This is formalized under 26 US Code, the law that allows the IRS to reward people who provide tips that lead to the collection of unpaid taxes. So there could be a possibility that this whistleblower is blowing their whistle under 26 USC for a potential payday. I'm assuming, keep it alleged, but the example here is that if you report a corporation or a person, and if they're hiding income in an offshore account and the IRS investigates and collects 10 million, as a result, you could potentially earn up to 3 million as a reward. So he's whistleblowing under 26 USC, whistleblowing against UMG and Drake. And if they end up finding something or find anything valuable to whatever he gives them, later on, it could result in a payday for them. Allegedly, I am past the bar exam. I'm just reading what I see here. It's all entertainment. Certification of independence. I hereby certify that this brief is submitted entirely independently, without funding, support, or coordination from any party in this case. I am not aligned with the plaintiff, Drake, defendant, UMG, or their counsel, nor do I seek outcome-based involvement. My role is solely as an independent memory holder, filing to preserve systemic truth on behalf of the public and creative communities affected by this matter. He says, in conclusion, for the foregoing reasons, I respectfully ask the court to grant leave to file the attached amicus curiae brief in support of neither party and to consider it a part of the court's preserved record in this matter. So he's trying to give some information to the court in regards to the UMG and Drake lawsuit. I don't know what this guy's angle is. I'm not sure if he's looking for some type of payout. From the last page that I read, it seems like he's just trying to come as a person with knowledge and not a person trying to look for a payday. Now, my whole thing is the whistleblower filing under 26 USC. He claims he's just trying to be a person that has all this information, all this data that he wants to present for the court. Doesn't have a dog in the race, just wants to give them the information. You file whistleblowing under 26 USC. Now, to be honest with you, just because somebody does file under 26 USC doesn't mean that they're always looking for a payout, doesn't mean that they're always trying to get paid. Filing under 26 USC doesn't have to be about seeking personal gain or recognition. Sometimes it could just be used to preserve the truth in the formal record. Filing a whistleblower claim creates a permanent official record with the federal agency, even if you expect no reward and seek no change. The act of filing itself preserves memory, legally, institutionally, which is why he says he's a memory holder. If your role is to hold memory, like he had said in the last statement, then it could just mean that you filed under 26 USC to honor your role as a memory holder. Filing can be an act of transferring that memory from personal witness to institutional acknowledgement. Even if the system ignores it for now, you've done your part and it lives beyond you. If there's a chance for a payout, even though this individual might not be looking for one, what are the chances of UMG saying yes to whatever he's trying to give them? And what if they say no because he files under this? Because now I'm thinking, even if that's not his intentions, right? Even if he's just saying, hey, I'm just a memory holder, I'm just trying to give y'all information, I'm not trying to look for a payday, I'm just trying to document this. And this is why I file whistleblowing under 26 USC. But it could go one way or the other. They could just look at it as you just documenting it, or they could look at it as the other way, you seeking a financial reward. Because you filed under 26 USC, and because it's structured that way, it's a law designed around compensation for whistleblowers, but that doesn't define your intent. But that doesn't mean that the court is going to look at it your way, because the court could just look at it like if you're just looking for a financial reward for helping them. And that could be a reason why they will deny any assistance from you. I think this is why he gives a statement of purpose. I think this is why he files this the way that he does. And if they let his documentation speak for itself, it might change the outcome of however the court looks at this person, Joe Cat, and the way they're trying to move. So just because the system is built around rewards doesn't mean your intentions get swallowed by it. Filing can still be an active witness, not profit, even in a reward-based system. It could be possible that JoeCat is just using this as a vessel, using the system as a vessel to preserve memory. However, I'm not sure what he has. I'm not sure what he knows. And I'm not sure if the court is going to look at it the way that he does. I'm not even sure if they're going to allow whatever information he gives them to be used in court either. I think the court is going to move forward depending on how they feel about this guy, JoeCat, whether they feel like he's being genuine or not, whether he's doing this just to help them or if he's doing this for a payday. I think the court is going to move forward depending on how they feel about JoeCat and his intentions. If they think that he's being genuine with what he's saying and how he worded his documentation, there might be a chance they might look into what it is that he had sent them. If all else fails, they might just tell him no, and we'll never see what information he was trying to give them, anyways. If that's the case, and they do tell him no, I think that he should just release that information to the public regardless. If it's information that he's received publicly and was able to get online, he should just post that information publicly for everybody to see. I guess that's why I don't know if he's being genuine or not, because if you had this information, you should just put it out there. But I guess if you're trying to do it the right way, you file so that way it could be documented. But who knows how the court is going to act? Who knows how they feel about JoeCat interfering? But who knows? There could be a chance that they say yes and they accept whatever information he gives them. And however that shifts the issue, however it shifts the argument that's going on between UMG and Drake, we'll have to see what they say. But I think it all goes back to the court and wanting to see if they want this guy's help or not. Do you think that this guy is being genuine? Do you think that he actually has data that could help the case? Do you think that he's filing whistleblower under 26 USC for personal gain? Or do you think he's just documenting it that way to take the proper procedures to proceed with this information in court? Y'all tell me how you feel. Like I said, didn't pass the bar exam. Just reading all this for entertainment. Y'all tell me how you feel and get back to me, man. Like, comment, subscribe, and I'll see you on the next video, man. Peace. Keep it a legend.